What are the sources of Hindu law? There are two types, ancient sources and modern sources. Ancient sources is Shruti and Smriti. Modern sources, commentaries and digests, customs and usage, legislation, judicial decisions, principles of justice, equity and good conscience. So Shruti. Shruti literally means that which was heard from above. The Shruti derived from the Sanskrit word Shru means to hear or say Shrut means heard. Thus Shrut plus iti equal to Shruti, meaning that what was heard and believed to contain the very words of God means what was heard by the rishis or sagas in revelation by God. Shruti was strictly means the Vedas, was in theory the root and original source of Dharma. It was supreme to the early Hindus like the Decalogue to the later Christian. Vedic literature. The Vedas comprise of six Vedangas, four Vedas, Puranas, Aranyakas, Brahmanas and 18 Upanishads. The four Vedas comprise of Rig Veda, which is the Veda of verses or shlokas, Samved, the Veda of chant, consisting of prayers composed in meter, Yajur Veda, the Veda of sacrificial formulate, and the last one is Atharva Veda, the Veda consisting inter alia of incantations, that is, the words used in magic charm. Each of these Vedas are divided into two parts. First is Samhita and the other is Brahmana. Samhita consists the collection of mantras or hymns which are being used to praise God. Brahmana related to the theological exposition of mantras. The Vedas are composite origin and include hymns by many generations of the early Aranyas. Next one we will see Smriti. Smriti literally means that what has been remembered from the beginning. Smar meaning to remember. Smar iti is Smruti. Smruti means recollections of rishis. These recollections of rishis handed down to us from generation to generation constitute the principal or main sources of Hindu law. By Shruti or what was heard from above is meant Veda. By Smruti or what is remembered from the beginning is Dharma Shastra. From these two proceeds the whole system of duties, Manusmruti. Shruti is again divided into Yajnavalkya Smruti and the Narada Smruti. Later we will see commentaries and digest. In the new social changes, legal rules underwent change. In an ever advancing society, a clear and systematic exposition of rules of law, legal concepts and principles were necessary. One smriti differed from another, and sometimes in the same smriti there were conflicting texts. Thus, the need arose for further analysis, systemization, and assimilation of law. This need was satisfied by the commentators and digest writers. The commentaries and digests cover a period of about 1000 years from 700 AD to 1700 AD. Commentaries modified and supplemented rules in the Smritis and also interpreted the language of Smritis partly by their own reasoning and partly in the light of usages that had grown up in those times. Customs. Meaning of custom may be defined as habitual course of conduct generally observed in a community. In other words, the term custom signifies that the fact where a number of persons are in the habit of observing certain things in their dealings with each other with the expectation that they would be followed by others. The Sanskrit equivalent for custom is sadachar, which means the approved usage or the usage of a virtuous man or good practices. Achar, sadachar, shishtachar broadly interpreted they mean practices of good man. Importance of custom. Custom is regarded as one of the most important sources of law. Narada said, Vyavaro hi balvan dharmasthe vahiste, meaning custom decides everything and overrules the sacred law. Manu regards approved usage as direct evidence of law. Immoral custom is transcendent law. Kinds of custom. Manu has declared that the peculiar practices and usages of countries, castes, and families may be followed in the absence of rules of revealed text, Vasishtha. Custom in Hindu law could be of various types according to Smritikas. The first is Deshachar, terrestrial custom confined to a particular locality. Varnachar, communal custom confined to caste, sect of community. Kulachar, family custom confined to a particular family. Pugdharma or guild custom, custom which is confined to the followers of a particular profession or occupation. Requirements of a valid custom. Essentials of a valid custom. In order that a custom be valid, it must be ancient, continuous and invariable, certain, reasonable. It should not be immoral. It must not be opposed to public policy. It must not be opposed to law. Now we will see legislation. Legislation is a modern source of Hindu law. The legislation is one of the most important sources of Hindu law. The importance of the sources of legislation can be examined from the number of angles. However, a few and fragmentary attempts were made by the rurals to indulge in piecemeal legislation. Legislation upon these subjects are Hindu Marriage Act 1955, Hindu Adoptions and Maintenance Act 1956, Hindu Minority and Guardianship Act 1956, and Hindu Succession Act 1956. By these enactments on the Hindu law, some fundamental changes have been introduced, though a total break from the past has not been made. Next, we will see judicial decisions. Three wings of democracy are legislature, executive, and judiciary, where legislature is to make the law, executive to administer the law, and judiciary is to interpret the law. Thus, under the canons of the common law, the duty of the judge is merely to interpret the law and not to legislate. But as expressed by Lord Denning, in modern days the functioning of judiciary has become so important and recurrent that it has practically acquired the importance of function of legislation. The judicial decisions have come to assume greater importance in the administration of Hindu law, and therefore at times they override the ancient principles. The judicial decisions have provided a prolific sources of Hindu law as they have constituted sources of many other laws. Really speaking, the courts of law are supposed to interpret the existing law and apply the same to cases coming before them. However, many a times it so happens that the cases coming from them are not covered by any of the existing laws, and therefore such cases are decided by them on the basis of the principles of equity and good conscience and reasonableness, etc. The decision in such cases by the courts constitute precedents which are followed by the courts in similar cases coming before them in future. Generally, the subordinate courts are required to follow such decisions. Other equivalent courts may or may not follow them. All important parts of Hindu law are found in law reports, and to that extent it may be said that decisions on Hindu law have superseded the commentaries. The decisions of the Privy Council and the Supreme Court are binding on all the courts in India. Lastly, we will see the principles of justice, equity, and good conscience. The auxiliary indices justice, equity, and good conscience to sources is very loose utilized apparently for the purpose of covering the incalculable distance that often exists between law and justice, or between the letter of the law and justice, or between the letter of the law and the spirit of the law. It over very often provided an excuse to escape from the rigid application of law. if such application would result in miscarriage of justice. When the question of examining the nature of Hindu system of law came before the lordships of the Privy Council in Kenchava versus Girimallappa, it was held that the system of Dharmashastra was so compact and replete that it must be deemed to have contained the principle of justice, equity, and good conscience. Therefore, their lordships held that under the Shastras a murderer must be deemed to be disqualified from inheriting the property of the murdered person, despite the absence of a specific provision to that effect in the Shastras. So this is all about the sources of Hindu law. Thank you so much. We will see in the next video.